We want to answer all of your questions, so please, we got about another 15 minutes. I'm going to keep going, but if you have any questions, just raise your hand and we'd like to answer all of them. Sir.
In an audit, how many years back do you need to go in order to satisfy the requirement of source documentation?
Yeah, we'd like to do the year end, and then we'd also need to verify beginning balances as well. So 1 year. And really, if it's the first year that you're starting, which most of all of this is going to happen, then, you know, bank accounts and all of that, we will see the open date, and then it's the ending balances. But say we're not getting in until year 2, then we would need to verify opening balances. Does that make sense?
Yeah.
Okay.
Another question, you referenced Regulation A and then A+, but you never really delved into A. Can you describe the differences for A to A+? Is it relevant? If it's not, then...
Yeah, it's really no longer, well, Regulation A is referred to as A+, so I think since the Jobs Act, everyone refers to A+. There are 2 tiers under Regulation A+. One tier, which is, some people refer to Regulation A, is Tier 1. That one allows you to raise up to $20 million, but it does not preempt state blue sky regulation. So that's one where you would have to qualify in every state. And again, because it's under Regulation A, you have to qualify the offering with the SEC as well. But there are some other relaxed requirements under Tier 1 versus Tier 2. One question, Dean, on the financial statements. Typically, the financial statements in offering documents, securities offering documents, will have footnotes. I know that after SOX, accountants, because of the independence requirements, auditors, were not able to really provide a lot of the work that goes behind drafting footnotes to the financial statements. Are there restrictions like that on a review, and what would the company have to do? Do they have to provide full-blown notes to the financials?
No, I'd say the majority of CPAs out there would go ahead and help you with that. I mean, they understand that we're going to have to help you draft the notes, and we would provide that service.
Okay, great. Question?
Yes, you mentioned convertible debt securities. Can you talk a little bit more about that? And also, do you have, does your platform support straight debt securities or just convertible debt?
Sure. So a popular way of raising funds initially when you don't have a valuation of your company just yet, because you're starting off, is you're looking to raise maybe $500,000, but on a convertible note, which means you will be able to, I guess you're soliciting investment up to that $500,000, but those people aren't necessarily getting a piece of your company yet. It's just when you give them the $500,000 into your company at a later date, probably with an interest along with it, you pay back the investors. However, a lot of investors like to, get into on the convertible note round, but then it really depends on which company, but a popular way of doing it is say, okay, I will finance your company through this debt offering, but then when you do have the next round of actual equity offerings, then we're going to kind of be the first people that have the ability to choose whether we want to enter that round or not. So that's a kind of difference of...
Is there a strike price indicated in the initial debt document, debt security, or is there a put or a call, or how would that be option? Is it like an option? Does somebody get to exercise one way or the other?
Yeah, there's all different kinds. I'll let Mark kind of talk into the technicalities of it.
Yeah, the convertible debt is today it's a very common form of seed financing. On the question about strike price, so the way the convertible debt works is it's a note, it's debt. Typically there's an interest rate associated with it that just accrues, and typically it will convert automatically at an qualified financing, which will be defined, and it will be defined typically as a first equity financing of a certain minimum amount. And so the note, the principal and interest, will automatically convert into equity at that price. And that's why, as Alan says, it's not, the convertible note offering is not considered a price round because there's no valuation as of yet. The valuation occurs down the road when the company does the first qualified financing. So there, in most convertible debt deals, there isn't a strike price. Now, there may be what's called a valuation cap, where the note holder is able to negotiate a cap on the total amount of valuation that he would be able to convert at, in which case he gets the benefit if the first financing, qualified financing round is at a valuation higher than that, he gets the valuation at the cap. And then also typically you'll see a discount for the note holder of anywhere from 5 to 20%. The note holder, when the qualified financing occurs, the conversion occurs at a discount to provide some benefit for the note holder, providing the early money. All right, another question, Dean, on this whole issue of debt. One of the, I think, questions probably most entrepreneurs will have is, what do I need to disclose? And the general rule that I have is, if you feel like you're something like you don't want to disclose it, that probably by definition under the law is something you have to disclose. But on debt, what kinds of disclosures do you typically see? Like repayment of debt? Tell us a little bit about what you think people ought to be looking at.
Yeah, repayment of debt schedules, interest rates, conversion factors. What you gentlemen were just talking about with regards to exercisable warrants and convertible debt, that ties right into what you were saying, Taylor, that you really want to match the level of expertise of the people that you're working with to where what you want to do and to the complexity of what you want to do. Because, for us at Armanino, we're very comfortable in crowdfunding because technology is our largest niche. So we get to see a lot of this complicated equity and debt structures. And it's one of the things that we look for most, right? In any technology associated audit, our number one risk is going to be revenue recognition, followed very closely by all equity transactions. It's where we're going to spend the majority of our time. So you definitely want to match. Now, with regards to debt, we do want to know repayment terms. We want to know, is it a related party? We want to know interest. We want to know conversion. Anything special about it in terms of rights and obligations and kind of all of that.
Yeah, and it's not uncommon, of course, for a startup when it's doing its first round of financing to have some debt, some friends and family, somebody's contributed, or the founders have contributed something. And one thing an investor wants to know is, how is my money going to be used? And one of the biggest questions is my money going to be used immediately to pay back the debt that the founders have incurred, right? And so, one thing I would suggest is to go onto the SEC website and look at IPO prospectuses of public companies to see the kinds of disclosures that they make. You'll see a very elaborate use of proceeds section. But one thing I'll caution you about on a public IPO's use of proceeds, typically you'll see a big category that is categorized as working capital. Well, for a company that's raising, tens of millions of dollars, they could kind of lump into working capital a lot of stuff that might not be considered material individually. But for a startup, most of, I think, the money is going to be used for working capital. So you will need to break out pretty specifically in a way that you won't see in an IPO prospectus how the money is going to be used. Question?
Understanding that you don't have a crystal ball, I'm going to ask you to look into your crystal ball. With little to no case law, obviously related to crowdfunding and other things like that, what potential legal liabilities do you foresee as possible for companies going through crowdfunding, especially with regard to investors?
Yeah, that's true. I mean, a lot of it is going to evolve and develop because it is so new. On the other hand, the somewhat draconian civil liabilities that have been on the books for 90 years since 1933, again, which, as I was saying, Congress enacted in response to the crash and the Great Depression, people jumping out of windows. So, there are fairly serious, significant liabilities if you mislead somebody, if you don't follow these rules. There are controlling person liability provisions that give rise to individual liability for the persons that control the company selling the securities. Because, of course, if something goes wrong and investors sue, the company has probably already spent the money. So Congress created individual, joint, and several liability of the controlling persons, people who actually control the company. And so they can be personally liable. The fact that there's a entity, an LLC or corporation, is not going to shield personal liability if you do something like mislead investors or violate some of these rules.
Mark, just to add to that, I think the real question comes up is what's appropriate for what level, and you guys have started to address that this morning. But if you're going in for just friends and family type stuff, obviously the requirements in terms of your paperwork, your backing, your due diligence on that is much less than if you're going to try to go into to a much larger raise. And certainly that brings up the next question, which is how do you sit down and talk through this with a potential person as they're going through this? When is it appropriate to do what stage of funding as it relates to that? So you have different requirements, obviously, for different raises, but then how do you sit down and consult with somebody through that process?
Yeah, Dean, you want to take a stab at that?
Yeah, I mean, after you have that proof of concept, and you've had that seed fund, the seed initial seeding done, a good example is SaaS companies. We talked to a SaaS company that wanted to get into crowdfunding the other day. And the interesting thing about all SaaS companies is that, and if anybody doesn't know, SaaS is short for software as a service, is that their challenges the day they go live and the day they get customers, their challenges, even though they might not have as many transactions, they have the same challenges of very large companies right away, right? Because if you're on the web, for example, a very common thing is nexus in numerous states, right? Multi-state tax returns and all of that, and the sales and use tax associated with that because you're on the web, right? You think, I don't have a person there, why would I have to file? Well, all of a sudden, you're selling product in all of these different states, and now, you have a question of nexus. So that's a good example. Another thing is all of a sudden, your product is taking off and you're starting to get international customers, right? So now what does that do? So it really becomes on, and normally for us, when we start to talk to people, it's, they've moved past that seed round, they do have that proof of concept, and now they're quickly moving towards a Series A, a larger Series A of maybe, $3 to $7 million. And now it's like, okay, well now let's start to track all of your transactions. We get that you're still going to be losing money, but there are still people who will want to be knowing exactly what you're doing. So that's really at the level.
Okay, I'm going to end it, and because we're running out of time. But let me just, one way to answer that question is, Chris, that these liabilities that we talked about, they're all subject to what's known as a due diligence defense. If you, the entrepreneur, can establish the due diligence defense, that is a defense to any claim. And that due diligence defense basically is that after reasonable investigation, you had no reason to believe in the false statement or the violation. And so, I guess we'll leave you with the parting message. What does that mean? Well, I mean, you just kind of have to manage your business affairs like you would manage your own personal affairs. Use a reasonable amount of diligence. The courts, judges, but for the most part, juries exercise their common sense. And if you can demonstrate and document that you have done a reasonable amount of diligence, reasonable investigation, and you had no reason to believe in any misstatements or that you were omitting to disclose anything, that will be a defense. So I think the parting message is be careful. You know, there are minefields and liabilities out there, but don't let that stop you. And, you know, courts and the laws are such that if you exercise reasonable diligence, then you'll do fine.
Mark, it's not a question, just a comment. First of all, it's a very complex area. It seems simple on the surface, but there's a lot of components and moving parts. You just wrote a book. Would that be a good resource for us to take a look at to help us sort this whole thing out, or?
Thanks for the plug, Mike. Yeah, I did write a book for Thomson Reuters, and it's available on Amazon. It is designed for entrepreneurs and kind of business lawyers who are not securities law specialists. And what I've tried to do is highlight those areas of risk, litigation risk, where it's probably advisable that you get some advice. And so I think the message in the book is that you don't need to hire some expensive lawyer, you know, expensive securities lawyer, but you need to get some basic legal advice on certain legal issues. And I try to identify where those issues are. Thanks, Mike. Thank you. My panelists, thank you very much for getting up early and sharing your wisdom.